Goldman went to the DOJ himself, then brought back 3 documents Bondi had one answer for. He did not ask for a briefing. Rep. Dan Goldman, former federal prosecutor, member of the House Judiciary Committee, went to the Department of Justice the day before the hearing. Not a congressional briefing, not a curated presentation assembled by Bondi's staff, not a summary prepared for political consumption. He went to the department itself and spent several hours reviewing unredacted materials in person. Goldman spent 10 years as a federal prosecutor in the Southern District of New York, the same SDNY whose 86-page prosecution memo he was about to hold up in the hearing room. He has read prosecution memos before. He has read draft indictments before. He understands what those documents contain, what they mean, and what the deliberate decision to withhold them from members of Congress says about the institution withholding them. His background did not make him hostile to the DOJ's position. It made him harder to mislead about it. He was doing the work that oversight is supposed to require, going to the source, looking at the actual documents, evaluating for himself what was and was not in them. What he found and what he did not find became the foundation of an exchange that produced 3 documents, one word repeated as a wall against each of them, and a room full of survivors whose raised hands answered a question the Department of Justice had apparently never thought to ask. Goldman came back with a list. The bill that required the release of Epstein documents had specific categories of material that had to be disclosed. Almost half of those required documents had been withheld, not redacted, withheld, not released at all. He had that number before he sat down. He had it from his own review, not from a government briefing, not from a staff summary, from the documents themselves. Members of Congress reviewing unredacted executive branch materials in person is not a common procedure. Typically, congressional oversight of sensitive DOJ materials happens through staff briefings, written summaries, or formal document productions that the department controls and curates. A member physically going to the department, sitting down with unredacted files, and reviewing them directly removes the intermediary layer that normally exists between what the department possesses and what Congress sees. It is oversight conducted without the department's editorial control over the information flow. Goldman was a former federal prosecutor. He knew what to look for in prosecution documents and what their absence or redaction would mean. His visit was not a symbolic gesture. It was a document review with professional consequence. Then he walked into the hearing room. He had organized what he found. The documents were in order. He was not going to give Bondi the opportunity to dismiss what he was about to say as second-hand characterization, because it wasn't second-hand. He had been there, he had read it, he was about to tell her what he had read, in a room where everything he said would be on the record. This channel tracks the documentation as it moves through the legal system. If you want to follow where this goes, subscribe and turn on notifications. New videos drop when the record produces something worth documenting. Let's start with what Goldman did not find. He acknowledged from the outset that 3 million documents existed and he had only a couple of hours. He was not claiming to have seen everything. He was telling Bondi precisely what he had reviewed and precisely what had been absent from that review. That honesty mattered. A member who exaggerates what they found is vulnerable to being contradicted. Goldman was not exaggerating, he was documenting. The first absence, the client list. Bondi had said publicly approximately 1 year before this hearing that she had the Epstein client list on her desk. That statement was reported. People were waiting for it. When Goldman went to the department and reviewed unredacted materials, the client list was not there. He said it plainly. He didn't find it. That absence sits against Bondi's prior statement in a specific and documented way. She said she had it. Goldman looked for it and it was not in the materials. 2 explanations are available. Either it was withheld, which would require an explanation for why a document Bondi had publicly acknowledged having was not in the released materials, or the original statement about having it on her desk was not accurate, which would also require an explanation. Goldman put the absence on the record without embellishment. He noted it was not there. The record contains that noting. Now let's talk about what Goldman did find. Document 1, an 86-page prosecution memo from the Southern District of New York. A prosecution memo is produced when federal prosecutors assemble their case analysis for internal review or for the purpose of making charging decisions. It is the document that lays out what the government has, what it means, and what can be proven. An 86-page memo represents substantial work, the kind of document that results from years of investigation, hundreds of witness interviews, thousands of pages of financial records, and the accumulated judgment of prosecutors who have been working the case. It contains names, evidence, assessments, legal theories, and the prosecutor's conclusions about who could be charged and on what basis. The SDNY produced this memo as part of its Epstein investigation, the same SDNY where Goldman spent 10 years, the same office whose prosecutors built the case that eventually resulted in Epstein's 2019 arrest. That memo, the prosecutorial analysis of the case against Epstein's network, was being withheld not just from the public but from the members of Congress whose legislative mandate required its release. This document was still redacted not just from the public but from members of Congress. Document 2, a draft indictment from Florida against Jeffrey Epstein's co-conspirators. A draft indictment is produced when prosecutors have assembled the evidence and legal analysis to support criminal charges and have begun drafting the formal charging document. It is further along in the prosecutorial process than a memo. It is the document that one step further becomes the filed indictment that initiates a criminal case. It names defendants, it specifies counts, it lays out the alleged conduct that constitutes each offense. A draft indictment against Epstein's co-conspirators means federal prosecutors in Florida had reached the stage of actually drafting charges against specific individuals connected to Epstein's operation. That draft was never filed. The individuals named in it were never charged. The investigation that produced a draft indictment against Epstein's co-conspirators concluded without those co-conspirators being prosecuted. The draft document exists. Goldman found it as a record of how far the case had progressed toward accountability that did not ultimately materialize, and it was being withheld from members of Congress who had passed legislation specifically requiring its disclosure. This document was also still redacted for members of Congress. Goldman asked Bondi to commit right there in the hearing room to immediately providing both documents in unredacted form to members of Congress. He called it not a complicated question. 2 documents, both from federal prosecutors, both documenting co-conspirators, both still hidden from Congress. Bondi said, "Well, I guess it is for you because you have a law degree and those are privileged." Goldman said, "They're not privileged, but we will discuss that later." He moved immediately to the 3rd document. Document 3, an email from Jeffrey Epstein to Ghislaine Maxwell, unredacted. Goldman said he found it in the materials he reviewed at the department. He said it included notes of statements Donald Trump had made about his prior relationship with Jeffrey Epstein. He held the document. He placed it on the record before Bondi could respond. Then he walked through the privilege argument, the argument he knew Bondi was about to make before she could make it. This sequencing was deliberate. By addressing the privilege question before Bondi raised it, Goldman was removing the cover that the word provides when it is deployed before a legal challenge. He was preemptively establishing the legal counter-argument so that when Bondi said privilege, the room would already have heard why that characterization was incorrect. There is no reason for this to be hidden from the American people. There is no privilege. There is no attorney-client privilege. He noted that Bondi was checking with her staff. He spoke directly to that consultation, turning to address the staff rather than the witness, because the legal argument he was making was one that a lawyer in that room would need to contend with. He told Bondi's staff, "This document is not under attorney-client privilege because it was sent from Jeffrey Epstein to Ghislaine Maxwell. Attorney-client privilege is a specific defined legal protection that applies to confidential communications between an attorney and their client made for the purpose of obtaining or providing legal advice. Every element of that definition requires examination. There must be an attorney, there must be a client. The communication must be confidential. It must be made in the context of a legal representation. If any element is missing, the privilege does not attach." Epstein was not Maxwell's attorney. Maxwell was not Epstein's client. Neither was a lawyer representing the other in any legal matter. They were both subjects of a federal investigation into the same criminal enterprise, a communication between 2 people who are co-subjects of a federal investigation, written in the course of their association with each other, is not a lawyer-client communication. It is a communication between 2 principals, 2 people who may separately have lawyers, but whose correspondence with each other is not protected by the privilege that would protect their correspondence with those lawyers. Goldman had not only made this argument in the hearing room, he had made it in advance, directing it at Bondi's staff specifically because he understood that the people advising Bondi on privilege questions were the ones who needed to hear a precise legal counter-argument. Goldman said it on the record before Bondi could say privileged. Goldman asked Bondi to commit to publicly providing the unredacted version so that the American people could understand, in his words, the extent of Donald Trump's lies about his relationship with Jeffrey Epstein. Bondi's response was not a legal argument, it was an attack. She told Goldman he was about as good a lawyer today as he was when he tried to impeach Trump. She asked if he had apologized. Goldman did not engage with it. He came back to the document. That decision not to engage with the attack is worth examining precisely because Goldman was a former federal prosecutor. He understood the function of Bondi's response. The impeach Trump attack is a political deflection designed to accomplish two things simultaneously: shift the terrain from legal argument to political argument, and put Goldman in the position of defending his prior conduct rather than pressing his current question. A witness who successfully makes that shift has bought time and changed the subject. Goldman's refusal to take the bait was not a sign of weakness. It was the disciplined response of someone who knew the attack's function and declined to let it serve that function. He had a document. The document's privilege status was a legal question. The impeachment proceedings were a different subject in a different year. He was not there to relitigate the impeachment. He was there to establish whether the email he was holding was withheld on a privilege ground that did not apply. Coming back to the document was itself a statement. It said, "The attack does not change what is in my hand. The document is still here. The privilege question is still unanswered. We are still in this room and I still have time on the clock. Will you unredact this? Privileged." That exchange, that single word repeated in response to every document, is the document the hearing was building toward. When a lawyer has a genuine privilege argument, they explain it. They cite the specific protection that applies. They walk through why the document in question falls within that protection. That explanation is what distinguishes a legitimate privilege invocation from a reflexive refusal to engage. Bondi did not explain. She said the word. Goldman had the documents. He had the legal argument. He had the counter-argument ready. Before she could make the argument, she said one word. 3 documents, 3 privilege invocations, 0 explanations of which privilege, why, or how it applied. She said it for the 86-page SDNY memo. She said it for the Florida draft indictment. She said it for the Epstein-Maxwell email. Each time, Goldman had provided specific grounds for why the cited privilege did not apply to the document in question. Each time, the specific grounds were not addressed. Each time, the same word arrived in place of a counter-argument, privileged. The pattern is worth examining at the level of legal practice. Goldman is a former federal prosecutor who spent 10 years handling evidence, running witnesses, litigating privilege questions in federal proceedings. He knows the difference between a legitimate privilege invocation and a rhetorical deployment of the word privilege without the legal content. A legitimate privilege invocation names the specific protection, explains how the document falls within it, and provides enough legal grounding to enable the opposing party to contest it. What Bondi was doing did not meet that standard. She was using privilege as a refusal mechanism rather than a legal argument. The word without the explanation is not a privilege argument, it is the refusal to make one. Repeated as a wall, as a surface that Goldman's specific legal challenges bounced off of, without finding a substantive response. Then Goldman moved to the pattern. This is the part of his presentation that was in some ways more significant than any single document, because it described not just what was hidden, but the specific logic of what was hidden and what was not. The law that governed the Epstein document release had one primary redaction requirement. The identifying information of victims and survivors had to be protected. Their names, their faces, their details. The people who were trafficked through Epstein's operation had a legal right to have their identities shielded in these public releases. That protection is not optional. It is the specific mandate the legislation built into the disclosure process. Goldman said the mandate was not followed. Victim identifying information was not properly redacted. The people the law was specifically designed to protect were exposed in the materials Bondi's department released, and simultaneously the materials improperly protected others through redactions that have no legal basis. The people the law was designed to expose were shielded. The people the law was designed to protect were exposed. Goldman said this was not a mistake. He had a specific document to support that conclusion, an email with the subject line Epstein victim list, 32 names. 31 were not redacted, 1 was. Goldman's point was surgical. Someone reviewed that document, someone opened it, read it, and made a decision about what to do with it. Someone chose to redact 1 name and leave 31 visible. That act of selective redaction proves the document was examined and a conscious decision was made about its contents. The single redaction establishes intentionality, and if the review was intentional, if someone was making conscious decisions about what to redact on that list, then the failure to redact the other 31 names was also a conscious decision. You cannot claim accident or oversight when the same document shows evidence of deliberate choice. The law governing the Epstein document release required victim identifying information to be redacted. The 32-name list is by its subject line a victim list. All 32 names on it should have been redacted under the statute. 1 was. The 31 that were not redacted are the names of people whose privacy the law specifically mandated be protected. The one that was redacted establishes that someone evaluated the list with the redaction requirement in mind and made specific choices about which names to protect. 31 names were left exposed, by choice, in a document that was reviewed by someone who understood what the redaction requirement meant. The people sitting in the hearing room behind Bondi, the survivors whose names were on lists like the one Goldman described, had lived through the period in which the disclosure they had been promised produced, instead, a release that exposed them while protecting others. They had watched their identifying information become public in a process that was supposed to do the opposite. Goldman's account of the 32-name list gave that experience a specific, documented evidentiary basis. One name redacted, 31 not, someone chose. The choice is documented in the document itself. Goldman called it what it was: intentional intimidation, a deliberate effort to expose survivors while protecting the people who should have been exposed. The federal statute governing the Epstein document release, the law that required the disclosure in the first place, built specific protections for victim identifying information into its text. Those protections are not advisory, they are requirements. The statute requires that victim names, addresses, and identifying details be redacted from any public release. A department that releases victim identifying information in violation of that requirement has violated the statute. The individuals whose identifying information was exposed have potential legal claims arising from that violation, claims that can include civil remedies against the government for the improper disclosure of information the law specifically protected. The institutional responsibility for that violation rests with the officials who supervised the disclosure process and made the decisions about what to redact and what to leave unredacted. Goldman's 32-name document was not just evidence of intentional choice. It was evidence of a statutory violation. 31 victim names were disclosed in a release that the law required to protect them. The one redaction on the same list proves the list was reviewed. The 31 failures to redact are documented in a document that Goldman put on the congressional record. Then he turned to the survivors. The documents were in the record, the pattern was documented. Blanche had said the victims had hopefully spoken to the DOJ. Goldman had a room full of survivors and 5 minutes left. The documents were handled, the pattern was documented. One question remained: had the department actually spoken to the people at the center of this investigation? They were in the hearing room. They had come as they had come to prior hearings because this proceeding was about accountability for what was done to them. They sat through Goldman's presentation of the 3 documents. They heard Bondi say privilege to each one. They heard Goldman explain why privilege did not apply to the Epstein-Maxwell email. They heard the attack on Goldman's legal credentials. They watched Goldman come back to the document. Goldman noted something specific that Deputy Attorney General Todd Blanche had said in a public interview the previous week. Blanche had said that any victim who wanted to speak with the department had hopefully done so. The survivors who were in the hearing room had not been passive in waiting for that outreach. Goldman's 3 questions established the specific shape of what had happened. They had reached out. The hearing transcript does not specify when each individual outreach occurred, but the show of hands established that those who reached out had done so individually, through lawyers, through representatives, and had received denials or no response. The accumulation of those attempts and their outcomes represents a specific documented pattern: multiple survivors, multiple approaches, multiple rejections. Goldman said, thanks to the incredibly brave people sitting in that room, he could actually ask whether that was true. He asked the survivors to stand and respond by show of hands. How many of you or your loved ones had actually met with the Department of Justice and provided testimony and evidence? No hands. Not one survivor in that room had met with the DOJ. How many of you had reached out individually, through a lawyer, through a representative, to offer to provide testimony and evidence? Every hand went up. All of them had tried to contact the department. All of them had sought the meetings that Blanche said they had hopefully had. How many of you were denied or ignored by the Department of Justice? Every hand, every survivor who had reached out had been turned away or received no response. The Deputy Attorney General's public statement that victims who wanted to talk had hopefully done so was contradicted by the simultaneous raised hands of every survivor present. Not by argument, not by testimony, by hands in the air in a federal hearing room. Then Goldman asked the final question. Despite the efforts by Bondi and her department to intimidate them, the improper exposure of victim identifying information, the selective redaction of the 32 name list, how many of the survivors were still willing to speak to the Department of Justice? Every hand, every person who had been denied, ignored, and in Goldman's characterization deliberately intimidated by the disclosure process, was still willing to provide the testimony and evidence the department had not sought. Goldman looked at Bondi. It looks like you have some witness interviews to conduct. That sentence is structured as an observation. It is not a question, it is not a demand, it is not a motion or a resolution. It is a declarative statement about what the documented record shows. The department has witnesses who want to talk, who have tried to talk, who have been turned away, and who are still available. A former federal prosecutor saying it looks like you have some witness interviews to conduct is saying this is what prosecutors do. You have willing witnesses, you have not interviewed them. That is a deficiency in the investigative record. The framing matters because of who was saying it and what he was saying it about. Goldman spent 10 years in the SDNY building cases by doing exactly what he was describing, finding witnesses, interviewing them, incorporating their testimony into prosecutorial records that either supported charges or documented the limits of the case. The most basic function of a federal investigation is to interview the people who have relevant knowledge. The survivors in that room had relevant knowledge. They had been asking to share it. The department had not asked to hear it. A former prosecutor who watched that dynamic play out in a congressional hearing room named it, in the most understated possible language, that sentence has a specific weight that requires examination. It is not rhetorical. It is a statement of institutional fact delivered in the understated language of a former prosecutor who has just spent 5 minutes documenting what the documentation showed. The department's deputy attorney general had said the victims had hopefully spoken with the DOJ. The victims in the room indicated they had not. Goldman produced the concrete version of the word hopefully. None of them had met with the department. All of them had tried. All of them had been turned away, and all of them were still available. The word hopefully is doing a lot of institutional work in Blanche's original statement. Blanche was the deputy attorney general, the second most powerful official in the Department of Justice, speaking in a public interview about victim outreach in the most prominent sex trafficking case the department has managed. His statement was, any victim that wants to speak with the department has hopefully done so. Hopefully is not a qualifier that functions as an intensifier or a hedge in official communications. It is a word that signals the speaker does not have access to the underlying fact. It means, I believe this is the case, but I cannot confirm it from the institutional record. A deputy attorney general who knows which victims have met with the DOJ says they have. A deputy attorney general who does not know says hopefully. The institutional question that produces is not complicated. The deputy attorney general is the second most powerful official in the Department of Justice. The survivors of the Epstein trafficking operation are not peripheral witnesses to a peripheral case. They are the primary victims of the most significant sex trafficking prosecution in American federal legal history. Whether those specific individuals have spoken with the department is information the Deputy Attorney General should have, not because the DOJ is obligated to track every case at the Deputy Attorney General level, because this is not every case, this is the Epstein case. The case that has consumed more congressional hearing time, generated more public controversy, and received more legislative attention than any DOJ matter in this period. The Deputy Attorney General of the United States did not know whether the victims of that case had spoken with his department. He said hopefully. The survivors raised their hands. They translated hopefully into a documented fact. Goldman yielded back his time, 5 minutes, 3 documents, 1 word repeated, 3 questions, 3 unanimous answers. The 3 documents are in the congressional record. The 86-page SDNY memo still redacted from members of Congress. The Florida draft indictment naming co-conspirators still redacted. The Epstein-Maxwell email about Trump's relationship with Epstein still withheld from public release. Each one was asked about. Each one received the same answer. Privileged. The surviving victims of Epstein's trafficking operation are in the same record. 3 questions, 3 unanimous answers. Tried to meet with the DOJ, were turned away, still willing. The department has the documents. The department has the witnesses. The department has not used either. That is the record the 5 minutes produced. Not an allegation, not a political argument. A documented accounting of what the department possesses and what it has not done with what it possesses. The 3 documents Goldman found in his DOJ review are available for anyone with the appropriate access to examine. The survivors' raised hands are documented in the transcript of the hearing. The Deputy Attorney General's hopefully statement is in the public record of his interview. All of it is in the same archive. Goldman said, "It looks like you have some witness interviews to conduct." That instruction is in the permanent record. It was made by a former SDNY prosecutor who went to the DOJ the day before the hearing, reviewed the materials himself, found the documents, identified the pattern, and then spent 5 minutes in a federal hearing room establishing what those documents were, why they could not be withheld on privilege grounds, and what the survivors' hands confirmed about the department's engagement with the people at the center of the case. The interviews have not happened.